I will be listening your presentation, and then in the sequence, I will have mine. And it's always a pleasure to be with Mediator Vikram, and I hope to learn more from South Africa perspective on all the many questions that Vikram are asking us in his symposium.
Now, only thing is that everyone would have heard all my questions. Now, the new things that are going to come up, let's hope. So, Veerash, thank you very much for being part of the symposium. And of course, you should have been part of other things in between, which you haven't been for whatever reason.
I'm here now. I'm here now.
Yeah, because we were supposed to do an episode of In Conversation with the Beautiful Mind. That did not happen. And after that, Veerash did not happen. It disappeared. Okay, so what I'm back
here. So thank you very much for inviting me.
Oh, thank you very much. What I'm going to get you in to tell us about yourself later. Let me just put this up at what we are doing, because it's good to know what we are here for. We are here for this symposium number 8. So mediation legislation, how, what, when, where, which, who, why of it. Of course, this is symposium number 8 and Veerash was in symposium number 1. So there's been lots that's happened in between in terms of the symposia itself. So that, of course, we will talk about. The important thing is, Veerash, please tell us about yourself. Then you give me that 30 seconds to talk about what has happened in between the last time and this time. And then we'll go into the topic.
I think more about myself can be found on the internet. it cuts down on our conversation time, because there's so much that can be spoken about, and you've given me an hour. So what I did was I quickly put together a PowerPoint presentation, because your topics are open-ended questions. So we could go on, and I've watched most of the conversations you've been having with other people. And it's so enlightening, so positive to hear that people are vested in the endorsement of mediation. And you, Vikram, you giving this platform, you bringing the communities, the people together. I can only applaud you. So well done to you.
Thank you.
I started out being a legal professional as an advocate. I'm an admitted advocate of the High Court here in South Africa. And it just became too much to handle as a younger practicing advocate back then, to see people, especially 80% of the people in my country in South Africa, being unable to understand legal processes. They couldn't afford it, so they would represent themselves. And when they get into court, and I'm watching there as a pupil advocate, they couldn't articulate properly what it is that they wanted, or what it is they could ask for in terms of damages, or even the legalese. They did not understand. The whole system, the building, the room, standing in front of a judge is intimidating. The environment was intimidating. It was intimidating to me, and I'm trained to be there. I'm qualified to be there, and they weren't. So I had to, at that point, mediation wasn't so much in your face. We do have now 37 pieces of legislation, even more, that speak to mediation. And yet then it wasn't something that was in your face, whether you could get a qualification in. What do you do with it? What is it? I've heard in previous talks, in previous conversations, people think of mediation as meditation. Even to this day, people think I'm a therapist. I do meditations. I do like candles, but I like candles. We all sit and talk about our feelings, even though we do talk about our feelings in mediation. There is that miscommunication, that lost in translation understanding of mediation. So I went down a rabbit hole and just started collecting skill qualifications, enhancing my skill set, realizing you will never know enough. So we as mediators who are vested in the practice of mediation, we are constantly upskilling. We are constantly learning to understand how better we can be in the practice of it. I got lucky, I would say, because in all of that, I've been asked to, what we use here, train people to become mediators. And I know you don't like that word train, Vikram. So I'm only saying it because that's how it's advertised out here, train to become a mediator. And I think in other parts of the world as well, train to become a mediator. So they do attend, I am a trainer, I am a lecturer in it. I write articles about it, I endorse it in the mediation in the media. I'm vested in mediation as a practice or a forum of dispute resolution. So that's where I am now. I mediate. I do mediate as well. I research a lot about mediation. I keep myself in the know. Hopefully, it's just now actually become more knowledge there is about it. You actually can't keep up with a lot of the research. So that is why I think your platform, bringing global leaders in mediation in their countries, experts in their countries, just gives us an ability to understand what is going on around the world. So thank you, Vikram, for that.
Thank you. Of course, lots that you're doing interestingly, but more, I'll tell you, I'd be more interested to find out who that artist in your family is. I see some interesting thing there. I think we can leave mediation. We can all keep doing that later.
The artist is my niece, Mila. She, if I actually showed you the entire wall, she's been drawing on my wall since she's almost 3 years old. And so I have her drawings, which starts right from below where that current drawing is to her height. And as she grows older, she comes and does her self-portrait on my wall. So it starts right from the bottom of the wall and goes up, and there's more. She's now 7. So she did that one when she was 6. And now that she's 7, I've got her self-portrait of her being 7 years old. So this wall will never, even though I'm renovating my home, will never be painted on because
exactly, you can't.
She's here with me all the time.
Yeah, the artist, you have to look back and say, yes, this is where the creativity was explored on my wall. Mila is now, of course, doing this internationally, but look at this. This is where it all started. It's important. Yep. Yeah. So the artist in the family has got her release. That's important. But when you say, look, 37 pieces of legislation, you say 1 hour. 1 hour is like going to be nothing when we go through all that. But I think that's the important thing about whenever this training thing comes up, and of course I do say what I say, but my concept has been, don't say we'll make you a mediator, because that is, I think, too much. If you can even do that to anyone, I'll be, that's amazing. You can make someone a mediator. Whatever other things, skill development programs that you're doing, very nice, but don't give them that concept that will make you a mediator, because that's, I feel, it's misleading them, and it misleads other people also who might want to in some way use mediators. Because I say that only people who can make mediators are the people in dispute, and they should be able to make anyone a mediator. I'm going to that extreme, of course, in terms of legislation also, because if they can't make anyone, they want a mediator, then I think there's a flaw in the legislation, and then maybe vested interests have come in. So we'll leave that out. So Veerash, please, mediation legislation, all yours.
Thank you. Am I able to share my screen?
Yep.
Okay. Can you see that?
Yes.
Okay. All right, there we go. Mediation in South Africa. So where we started, and I know I mentioned 37 pieces of legislation, and we won't have time to go through all of it. So I'm going to be giving overviews of everything that I discuss. When we break into conversation after my presentation, Vikram, you're more than welcome to go into what I've presented today. And I'm sure also just my additional thoughts on what it is that I'm saying here today, and ask me questions on this, please. So mediation in South Africa, we started off in South Africa with mediation as a dispute resolution forum amongst the communities, amongst the tribes, the chieftains, the heads of communities, and currently as well, heads of households. So there was always that inkling to use mediation. Well, they probably didn't refer to it as mediation back then as a term. What we now know it as mediation is bringing people together, having one person mediate, facilitate the discussions, and there being an outcome that is suitable for everybody in that dispute or conversation. What they didn't want was for people to have animosity amongst them, because they had to function as a group, as a tribe, as a community, and to lessen that animosity, to lessen that negativity, and wanting to keep that community understanding of we all are here together, we all work together. Then we had colonization, we had apartheid, and that brought in the adversarial systems, legal systems that controlled people, that did away with freedoms, that people had freedom of movement, freedom of expression, basically freedom of being not yourself or being who you are, but then having your privileges, or if you had any, limited. So that led to the legal system created to control people. I didn't see it as rules and procedures that were equal or gave fairness. It was legal systems that controlled people. And yes, we did have justices, we did have judges, magistrates, judicial officers who did in their own way try to assist people who had limited privileges and limited access to the courts to try and give fair hearings. Not many during the times of colonization and apartheid. Now in our democracy, mediation has become part of our dispute resolution system. Like I've said, more than 37 pieces of legislation include the word mediation. And customary methods of mediation that were used prior to colonization and apartheid are now forming part of our legislation as well. For instance, in our Children's Act, we talk about lay forums where the chiefs and tribal leaders, household leaders, heads of community can mediate outcomes in any disputes that are family related. That's according to our Children's Act. It's now made its way formally into legislation and is now a mandatory consideration, very different to it being mandatory in terms of a process that has to be done prior to litigation. It is now, prior to litigation, a mandatory consideration. Now, as part of your questions, what, when, how, what we know about mediation and litigation, and I'm sure many of your speakers are leaders in giving this information in their respective countries. The common knowledge between countries and globally is mediation versus litigation. And I refer to it as mediation and litigation because I think of mediation as an ancillary process to litigation. I don't think of it as choose one over the other, because I see it as one, mediation being an access to justice and litigation being an access to courts. And why I want to talk about this difference is when mediation started becoming popularly known as a practice in South Africa, people, and we've also now have this democracy, we have this constitution, everyone has access to courts, which they previously didn't have, is people thinking, if I go into mediation, does that mean I give up my access to going into a court, which is a right I never had before? And to alleviate that, we talk about mediation giving you access to justice. So you still have the opportunity to reach a resolution outside of a court, but still getting the process of having a structured process, having a proper mediator, having even judicial officers be the mediator. So, and if for whatever reason, mediation does not reach settlement or does not come out with an outcome, you can still go to the courts. You can still have access to the courts. So the apprehension people had of losing a right they never had before is now translated to you still have access to justice through the form of mediation. We are not taking away your access to courts. So that is the distinction I wanted to bring about in why, yes, we do know mediation is access to justice. We talk about that generally. And litigation is access to courts. But in South Africa, that fear of not having an access to courts still bubbles up for people for generations that didn't have these rights. This was prior to democracy and prior to a constitution. Now, when I look at justice, what does justice mean? And I actually thought, I'm saying access to justice. but what does justice mean? And let me just be basic about it. Let me just say, okay, what is it? What is it defined as? And in the Collins English Dictionary, one of the definitions, or a very summarized definition, is justice is fairness in the way that people are treated. And if we look at mediation, how are people treated? What is the process? Is it fair? So voluntary and flexible is what makes up mediation. It's confidential and without prejudice, with negotiations that happen inside that mediation. So what that means is you're not held to whatever offers you make, whatever options are on the table. It's not cast in stone. What I say when I'm working with my delegates and students is it's written in sand at that point. You have an impartial person. The outcomes are in the hands of the participants. There's direct communication, and they could be partial settlement or full settlement, or discussion around what needs to be handled in terms of a dispute resolution process. What are the issues? Let's narrow down these issues. If there's an ongoing relationship, you want to work on that relationship to understand for how long are we going to continue this battle? For how long are we going to continue hating each other, this negativity towards each other? If we're going to have an ongoing relationship, for instance, we're going to work together, or we have children that we have to raise together, what are we going to do with this relationship that we are now mandated to be in? And mediation then provides the tools, or provides an example of how do we communicate. You can even put in writing, what is the best approach to our communication? Let's use the structured approach just so we can get an understanding of how to communicate with each other without the negativity, without the battle cry. And it is a role model of collaboration. So people using mediation, they start in the, and what I see in my own practice, working with people in mediation, and we sit over sessions, they start to understand what that collaborative model is. What does it take to be collaborative? Because the mediator is the translator. The mediator takes the language that they hear, and they translate it into a collaborative voice. They turn the negative into a positive. They turn the harsh questions, or that cross-examination feel that comes out of being asked a question by the other person, the participant in the mediation, they turn it around into an open-ended question. They bring in the concerns, they bring in the interests, they bring in the needs, they address the fears. So the whole process becomes a role model of collaboratively working towards an outcome. And what we know about litigation, yes, it is an access to courts. Adversarial, because people are sitting across from each other, wanting to take each other out, wanting to win. There's that win at all costs. There's the cost for a legal representative, because if you were to, like I said, enter into the court system, go into a courtroom, you're going to be fumbling about, trying to understand, how do I do this? And intimidated. So the decision maker here is not the disputant, it's a judge or a judicial officer. And in some instances, even in the process, the disputants take a step back and they want the legal representatives to make decisions for them in terms of what is the strategy, what are we going into to negotiate on. They've lost their voice completely, or they surrender their voice, more likely. They surrender their voice to their legal representative, to the court system. There's no direct communication between the disputant and the other disputant. They work through the system. They use communication through their legal representatives. They use the court to communicate with each other. And sometimes things get misinterpreted, words get misinterpreted, intentions get misinterpreted. There are delays. They are where someone is not prepared. They don't know what is coming next. So they go into court and they delay the process. Either their legal representatives are not available. The dates are mandated in terms of you've got in here, you've got 10 days or 5 days or 15 court days to do certain processes. There's the rules, the timelines that they held on to. And then people start to get nervous about not or missing, then they've got to do additional paperwork for that. And then there's the lack of responsibility of the outcome, which I'm going to delve into later as one of the challenges facing mediation and the use of mediation. Of course, there's the false hope given by legal representatives or people who say, well, when I went into court and this is what I came out with. No, not necessarily, because your circumstances are different. The competency of your legal representative could be different. So you're not sure what is going to happen. And then there's the destruction of the relationship, because there isn't that communication stance of how do we transform this animosity that we feel towards each other for whatever reasons that brought us to in this relationship to break down or cause us to not communicate effectively what we want out of this. It destroys the relationship, the ongoing relationship. If again, it is possible to have one, it destroys that ongoing relationship. So what we know, to answer the what question, how I interpret it is what we know about mediation and litigation. Now, realistically, in South Africa, as wonderful as mediation has entered the building, is it lost? Does it know where to go? Do people understand how it works or where it fits in? There was a blasé approach initially in South Africa about should we use it? Should we not use it? How effective is it? And then we got the court annex mediation program running. It was a pilot project in certain provinces here, the Gauteng province in which I practice and live in. It was quite implemented quite well in there. However, everyone was gung-ho about it. Everyone joined a register of court annex mediators. People started going in to be trained. Everyone wanted to be a mediator. Legal practitioners at that point going, here's another source of income, let me become a mediator. And not really understanding where are we going to find the work? The courts are going to provide it because of the court annex mediation program. The courts are then going to provide the work. But it started to unravel and fall apart because the clerks that were involved in setting up, registering participants to the mediation weren't properly trained. Things started to fall through the crack. And so right now, I'm not sure how popular it is. I know there are some organizations that went and set up camp outside the magistrate courts, their districts, and offer mediation services. They just bring in a whole bunch of mediators and distribute the work amongst themselves. And that was happening around 2014, from 2014, because we had the new magistrate court rules that said, here you go, you get 40 hours of training and you're a mediator, put yourself on the roster, here's some tariffs you can apply and you can charge for that and carry on mediating. Then it died off for a while. The popularity of it, people went back to the tick box system. We'll try it, especially using private mediators. We'll go in for a session. And I saw an uptake of that in my own practice, where people come for one session. Of course, they book an hour. They get into it. An hour is not enough. They want to come back just to understand the process. And then their legal practitioners realize the clients are actually enjoying the process of mediation because they are talking to each other and they're starting to work towards a settlement. And now that's impacting my pocket. So then you'd get a letter from one of the attorneys or even the client saying, this is not the right process for us. We want to try and meet with our lawyers, see if we can reach settlement there, or this person is being unreasonable. I want to go to court. There's nothing much we can do. People have the right to access the courts. And as mediators, we go, okay, thank you so much for coming, but our doors remain open should you want to come and work on your negotiations. And that is something I also tell my students and delegates. You always say, it's not a failed mediation when someone walks away. You didn't fail. You didn't fail. That is how it is currently. That is the practice. That is what is happening realistically in South Africa. And I'm sure around the world as well, there are some jurisdictions who face the same issues where mediators think, I didn't do a good enough job because they didn't come back to finish it. It's not about you, really. It's about the participants. And they are heavily influenced. They are also fearful. They don't know what the process is. They're being guided by their legal practitioners. And if you have a non-mediation friendly legal practitioner, then the chances are this mediation is not going to reach settlement with you as the mediator. Now, what then happened around, well, COVID hit in 2020, end of 2019, 2020, everyone went into lockdown. And around that same time in March 2020, suddenly there was this High Court Rule 41A that amended how processes happen in High Court litigation. And what that meant was practitioners and their clients must consider mediation before going to trial. And again, legal practitioners go into a frenzy. They don't understand what is going on. What is this mediation? What are the expectations from this rule? People start reading it as mandatory mediation, start talking about it as mandatory mediation. It wasn't mandatory mediation. It's a mandatory consideration to attend mediation. You have to, now there's rules. You've got to notify the other person and invite them to mediation, either the plaintiff or the defendant or the applicant or the respondent, whomever. You have to now notify. Now there's rules of engagement. There's a process. Okay, people don't understand what that process is. And everyone's lost in the system. Okay, now you've got to explain to people, those of us who are practicing mediators for a while, it's more like an invitation. You invite the person. And the only thing I saw positive is people were wanting to understand, okay, help us. We don't want to get this wrong. Because we do have case law that wraps the legal practitioners on the knuckles if they cause their clients unnecessary costs on issues that could have been mediated. So on the back of that case law came around High Court Rule 41A, and legal practitioners now have to be conscious of going into mediation to at least attempt it. We're not saying you're forced into mediation. We're still saying reaching an outcome is voluntary. Staying in the mediation is voluntary. We need you to consider going into it and to see if there's a possibility of reaching a mediated outcome. And the expectations from the rule were do it within 30 days, then apply to the court if you need an expectation. It seemed friendly enough, not the best set of rules. It was friendly enough. It finally gave South Africa a definition of what mediation is. Maybe it could be tweaked a little bit more, but right now, at least we have a definition of mediation in terms of that rule. What it also introduced in that rule was the agreement to mediate. A lot of people did not understand how important that document is to mediators. Here in South Africa, we don't mediate if the participants or anyone involved in the mediation does not sign that agreement to mediate. It became a founding document to start the process. And it actually gave us as practitioners the opportunity to have client intake sessions to explain what the agreement to mediate is, to explain the contents of the agreement to mediate, and then to also do a brief introduction of the principles of mediation and why choose mediation. So the mandatory consideration of mediation in disputes, of course, not crime related, adheres to that voluntariness principle of participation and remains optional currently in the system to reach agreement. Now, it still does not place mediation at the forefront of attempting to resolve a dispute. You can use it to narrow the issues, which is what I say when I'm with my students and candidates. Use it to narrow the issues, because your clients come to you and they tell you these long stories. you're entertaining them because you make fees out of them. The longer they sit with you and the longer they drone on about their issues, that's nice. It's very nice that they can trust you to tell you everything. What the mediator is going to do is take that information and draft an agenda and narrow down the issues, so we can start moving forward from the session number 1. And also what mediators do is they work on understanding, do we have an ongoing relationship that we need to preserve? Now I need to understand what my strategy is as the mediator. And all of this comes through mediation advocacy. So realistically in South Africa, mediation is here. We just need more advocates to endorse the use of mediation. So where are we using mediation in South Africa? Popularly in workplace mediations and labor disputes. I do get called out a lot to organizations and to handle workplace disputes, to institutes, to universities, to schools. There are inside these organizations and these institutes, there's challenges of communication. A lot of people come from different backgrounds, different cultures. We have 11 official languages. So a lot gets misinterpreted, especially if they're in an environment they haven't been in before because of certain privileges that were not given to them, and it's new to them, and they're slow at adapting to it. So in that instance, mediators bridge the gap of understanding. They bring in that communication tool to translate from the one person what their expectations are to the other person who didn't understand properly what those expectations are. And those are the workplace disputes I've been working on in the past few years. In family law disputes, just the labor law dispute, we have our CCMA, conciliation, mediation and arbitration center, that courts that or forums that work on labor disputes, and mediation is inside there, but not commonly used. It's mistaken for conciliation, where you have a conciliator. It's not the same thing, where an outcome is expected in that one session that you have. I think they set aside an hour or 2 hours, and they need an outcome for this because the conciliator or the commissioner sitting inside there, it's on their track record that there be a settlement. Mediation, not so much. We know as qualified mediators, as skilled mediators, it is a process. There's a structure. There's a skill that you need to do in terms of mediation. To me, conciliation, they sit and they have a discussion and they ask, are there any offers? And offers are made, and so it's over and done in a matter of hours, or less than an hour maybe. In family law disputes, here we're seeing a rise in mediation because our Children's Act mandates mediation, especially where children are involved. And what that adds is one additional process, in that we hear the child's voice. We may use other professionals to do it. The child's voice must be heard on that mediated parenting plan or parenting schedule. They need to know what are the contents of that. So if children are involved, then mediation is right up there as the first port of call to reach some sort of understanding of what the issues are in dispute, and how to reach an understanding of what that contact schedule should be, what the care of the children should be. And in family law disputes, we are seeing a rise in mediation, I say with at least one session, I think, because again, people don't know what it is, but the legal practitioners are bound to consider mediation. So we are seeing people at least attempt one session of mediation. Commercial disputes, I'm seeing a lot of our practice. We see a lot of mediations in commercial disputes around contracts, negotiations, in terms of outcomes, service level outcomes. We are involved in negotiations as part of dispute resolution, more facilitating it. We see mediation come in where the organization realizes that whatever the dispute is has a greater impact on the public, but it needs to remain confidential. So they do use mediation in terms of that. Who is the mediator? I think globally, there are different standards. Currently in South Africa, the standard is 40 hours, a minimum of 40 hours. I don't believe that's enough. And I'm a lecturer in mediation. I train people in mediation. We say that anyone can become a mediator. And here age is a number. Of course, you have to be over 18 years old. But anyone at any point, you could be retired from whatever job you were doing, and you can go get qualified as a mediator. In our Children's Act, we refer to a suitably qualified person. So when we talk about who can conduct a mediation, there's a list of professionals that they give, and then they add as a catch-all, a suitably qualified person. And then when I talk about a suitably qualified person, I just think that 40 hours shouldn't be the minimum, because what can you learn? Who are you? Who do you become in 40 hours? It's a practice. You need to work on it. And one of the foundations of being a mediator, because it's unregulated in South Africa, is there's an expectation of behaving ethically. I don't see that in most instances when cases come to us or disputes come to us that started in a mediation and they weren't happy with the mediator. One of the parties was not happy with the mediator, and then they bring it to us. And one of the reasons was the mediator and the legal representative of another party. So those dual roles, there's a conflict of interest there. It doesn't seem ethically sound to have a dual role in that mediation. I talk a lot about biases, and in South Africa, we are laden with biases because of our past, because of the past practices, the patriarchal system that we have that is still flourishing, the privileges that the few had and not the many. So we're all laden with biases, and you cannot, and we talk about a neutral mediator, we talk about an impartial mediator, but we're not 100% neutral, we're not 100% impartial. We can choose to practice neutrally and choose to practice impartially. What I look at, and that's why I say fair practice, is we conduct ourselves fairly. What we give to the one person, we give to the other person. If we give 1 hour of a caucus time and individual session time to one person, we should be giving the other person, the other participant, 1 hour of caucus or individual session time. We need to practice fairly. We need to practice ethically. Managing brand and reputation. I talk about this a lot when I do work with my students, because of the use of social media, the use of Instagram and TikTok. It's popularly used to advertise your services as a mediator, to advertise who you are as a mediator, that you are now qualified to be a mediator. And that's wonderful, because you are spending less costs on advertising and more time letting people know what your competency, area of competency is. So that's wonderful to use social media. However, use it responsibly. Understand that what you put out there, what you talk about, impacts your capabilities of a mediator, in your reputation as a mediator. So those are just my insights on who the mediator is. Why mediate? Well, because we are constantly in a relationship. We are humans. We are in a relationship with people. It builds a better way to communicate. We learn how to be patient. We as mediators, we know what active listening is. We know how to, we are skilled in understanding how to practice it. What we can do then as teachers within our profession, we now teach people how to communicate, to make that relationship more, to make that relationship healthy, to grow a healthy relationship beyond the mediation. Unpacking the perspective to understand the thinking, I think that is one of the mediator's key skills, in addition to active listening and the communication skills, is using their language, the mediator language, the mediator tools to unpack perspectives because of that animosity, because of that lack of refraining from understanding. And also there's that upbringing of, and I spoke about the patriarchal system of, especially if they, whatever it is, the difference in people, their background, their gender, their socioeconomic status, people don't want to listen to other people. They think, well, I'm right, you're wrong. And mediators can unpack that, give different perspectives. Maybe the difference is we're not talking about the same thing. We're not talking about the same issue. I'm talking about black, you're talking about apples. So what is it that you're actually communicating about? Why mediate? Step out of the comfort zone of chaos, disruption, coercive control, and have the courage to change from destructive to constructive. We are so used to being negative, to creating chaos around us, to misunderstanding, to have conflict around us, to be sitting in a, to not listen when someone is talking to us, but we are waiting to reply, we are waiting to defend, and we are comfortable in that. To change your way of interacting with people, to actually listen to them, to not be listening to reply, is difficult. And we know this as mediators. That is why I'm constantly talking about upskilling. It's difficult. We do not get it right the first time. So we need to teach and work on skilling our participants, on moving away from that comfort zone of chaos and destruction into a different zone of understanding. Giving a voice to the silenced, well, we always see it in mediation. There is someone who is less vocal than another person. And we as mediators, we can see that. We are like drones. We have a perspective that looks down on what is happening. We have an out of box view on what is happening. So we can see, using our tools of individual sessions, using our tools of our questioning, our communication skills, of extracting the voice of people who would not normally, if they were in a court system, if they had legal representatives sitting there and speaking on behalf of them, wouldn't normally talk about what they're feeling, what they would like to see the outcome is, or at least have some input on what is going on in their lives. Bringing in the right people into the decision-making process in mediation, and if you're someone who doesn't know anything about mediation, we work with various professionals. So it's not just a legal process. We bring in financial advisors, psychologists, therapists, whatever is necessary to move the participants forward, to move them in a direction that is helpful. We bring those people in what they need, because in that negotiation process of the mediation, they need to be able to fully understand how to make decisions. Do they need objective criteria? Who do they need it from? And as a mediator, we assist, we guide, we never advise, we inform, we guide people to understand, who do you need to bring in here to help you make a better decision? So mediators do provide that to the participants. The motivation to mediate, it comes from, and I see this, and you would have seen this, Vikram, in people who become mediators. They've been personally, they've experienced long litigious processes. They've experienced the court system, and they realized this, like I realized back then when I was a junior advocate, this is not the way to treat humans. This is not the way humans should be engaging with each other. We're doing more harm, more damage. We're taking away resources that they barely have. So The motivation to mediate is now coming from people who have gone through court processes and they've realized, I just wasted time. I just wasted money. I could have sat across a table from someone and spoken to them directly and told them what it is that I need or what it is that they want to offer to me and how can we make this work. So that motivation comes from people who can see once they become qualified in mediation and they choose mediation to become qualified in, they can see how can I now take this and give it to other people. A motivation to mediate is after they come out of the litigious process or trials, they wish the other person in the dispute would have given them the voice to speak. And so they see mediation, the mediation environment as a safe forum, as a forum that allows people to have a voice. It opens access to information. And I always say this to my students and candidates, especially the legal professionals who come in to be qualified as mediators and they talk about advice. I'm going to advise that person. You're going to inform the person, because whatever you say to the one person, you're going to equally say to the other. You cannot advise one on the prospects of their success. You cannot advise the other of how terrible their options are. You can inform them. And mediation now gives you an open access information because it's such a flexible process. There is time to go and get that information. There's time to consult with people who can give you actual figures. We're not leaving you to drown. We're giving you that time. Today's child is tomorrow's adult. We know that. So parents should model dispute resolution skills that are not negative and that are in the best interest of their children. Children hear what you're saying. They're watching you. And if it doesn't even have to be you going through a divorce or a separation, if you are, they're still there, they're present. If you're on the phone talking about how you're going to deal with someone that you're having a problem with, they're listening to you. If you're separated and you have your children with you and you're working on a legal strategy with your attorney quite loud, they're going to hear you. So what are the dispute resolution skills you want to impart on them as part of your legacy as a parent? What do you want them to know? How do I deal with other people? How best can I deal with this? If they were you, how would they deal with it? Ask them. Children, like you see, I support their creativity. They can come up with creative solutions. So to speak to them and getting them to understand how solutions driven you can be, instead of being distracted, instead of destroying relationships, instead of imparting this negativity and I hate to use this word. I'm going to use hate because I hate to use it. The word hate towards someone, the hatred towards someone. Make it commercially attractive to legal practitioners. Well, that's a long haul. That's a long story that we can start talking 10 years ago and going into the future. What I saw in that frenzy of moving between court annex mediation programs and people starting to want to be qualified as mediators, and then Rule 41A and people wanting to become qualified as mediators is, I'm now qualified as a mediator. What do I do with this? How do I earn an income from this? So there needs to be an income generated from being qualified as a mediator. And then we'll get the buy-in from legal practitioners. How can it be commercially viable for them? More changes I needed, and I'm nearly done. More changes I see needed. The participants in mediation need to show that they've made vigorous attempts to settle or at least narrow the issues, and legal practitioners as well. They need to show that we really tried. And legal practitioners on the sideline, they should not be behaving negatively towards the mediation process. As I've mentioned, mediation in South Africa is currently unregulated. We do need to regulate the profession, especially around qualifications and upskilling, without that exploitation and dishonesty from these institutes and training schools that are being created. Protecting the mental health of the mediator if I know many mediators who do mediations constantly as part of their profession, sometimes even they get lost in their mediations, especially dealing with high conflict people. They doubt their competencies. High conflict people are intelligent people. They can break you down. So we need to form a support system for mediators, a hub for mediators to just come in there and transfer that energy that negative energy that came in from a high conflict mediation, and get some advice from mediators who've been there. Mandating that legal professionals, including judicial officers, attend mediation advocacy training or information sessions at the very least. And I've seen this with my mediation advocacy programs that I run, is legal practitioners do want to know, what is this? How do I fit in? And it's taking up. I see other institutes and other organizations as well doing mediation advocacy. And I think that's brilliant. I think this platform, Vikram, that you've created doing mediation advocacy is excellent. People need to know what it is. They're not sure of it, so they are fearful of it. So here we have the South African Law Reform Commission, and they're working on making mediation mandatory in family disputes so that we alleviate at least part of that court system that we have. And that's me. Thank you very much. Sorry if I took up way too much time. That's why I needed a PowerPoint, because I can go on and on. So thank you all very much for listening to me. And yeah, that's me.
Thank you very much. Of course, there's lots to discuss, but what I did not do, which I should have done before that, was to talk about where to find information about the work that I do.
Oh,
because
yes.
that part of it is a bit important for me, because for me to put out social media posts and everything is a time-consuming aspect. Why not just find some place and go there and just find the information? So mediatorvikram.com definitely is a place. Is like, think of it as a notice board for the work I do. So if you just come there. So this is pinned on the board because this is a new series that I've started. And of course, well, connecting and everything is all there. But this is important, which Veerash, you will have to have a look at it later. But World Mediation Circle, and these mediation circles are important because you're working with organizations. We need to create mediation circles in every organization. So if you have that kind of an environment created, but the point is not as normally, of course, my approach is a little different. I'll get to that. Of course, support in events and all is all there. So last year's events and that Woodstock of mediation as the one that you participated in, all that information is there. But the important thing is that we are not going there to teach you anything. That's that's the approach that I have. We are going to find out who already knows everything. Who are those people who have that mindset? Just bring them out. We are putting them together. The skill development part of it is another aspect which is I'm working on, so that it will be available, and of course you'll be part of. I want you to be part of developing that, so that's going to happen. So those are the kind of things that are happening. I think the important thing that I need to discuss is access to justice, but we won't have time to discuss it. That's the only thing, because I think that by even saying mediation is access to justice, I feel to a certain extent the judicial system is finding a release. One release is to how to get the backlog off, and they're calling it access to justice in some places. I just feel that this is misleading people, it's fooling people, because is it really justice for them as the way they see it? Is it something which is justice more an interest based or a rights based? What is it? It's a rights based concept. Did I get justice? And if we start from that, when they come into mediation, they're going to look at it differently. Oh, my rights are going to be enforced, because that's what I look at justice. And then they come, oh, these are my rights are not enforced, but I'm in a process where, yes, I'm trying to collaborate, I'm working it out. So that kind of an approach is what we want them obviously to have. But when we put someone in a process saying that this is access to justice, I think we're putting them in a process which now they're always questioning it from that angle. Oh, am I getting justice? Am I getting justice? Look, let's not just that justice part, keep it to the courts. You forgive them justice. You're denying justice, you'd give them justice. You're inefficient, become efficient. Get that word out of us. We are here This is their process. We're working together. Justice is not a word we want to bring in here. Collaboration is the word we want to bring in here. A relationship building, relationship strengthening, healing. We want to bring those kind of words. So keep your justice and those words there is my view on this. But it's a discussion. We have 6 minutes, so we won't be able to get into it. I'm not going to ask you to come in because it'll go into that direction. So the other part is that, of course, in terms of how you look at legislation, considering one, the way mediation is in South Africa, what is the kind of legislation that you would want? No, you're not bound by anything that is happening, what is existing. How would you're the legislator, you are the one who's going to decide. So what legislation would you want? And on the global level, how would you look at it as to when we are going to work globally? What is the legislation domestically that should be there? And of course, globally, we are talking about the Singapore Convention. What your views on that are? Because you don't have too much time. That's the only thing. So I'm trying to put it down like this for you. Yeah, Veerash.
Okay. I'm sorry we don't have time to do the access to justice thing, because I want to tell you.
I know.
There's a definition of justice we need to look into.
Yeah.
So how do I see it? Well, in South Africa, it's piecemeal right now. It's piecemeal. It depends on who is popular in our Department of Justice at that point, and suddenly we get something. Like I said, Rule 41A pops up. Known mediators, known organizations were not consulted, and they said that. What is this? We are doing this. It doesn't match what we do. I think in that terms, in terms of drafting legislation, have the right stakeholders in those meetings. Have the people who are actually on ground level working.
No, but today we won't have time for that. We'll have the time for what should the legislation look like? What are the clauses you would want? So Veerash is the only person. She's the person who leads the country. There's no one else in the picture.
So firstly, I would put the right people in the room, and then we start talking about
people. You're the right person. Well, let's go.
Okay. So I would see to regulate the profession, recognize the profession, recognize it as a profession, increase the number of hours or the qualification itself to upskill people, have in terms of the profession itself, have it be a continuous professional development process. And of course, mediation advocacy, just inform the people, constantly inform the people of the benefits of it, the use of it, the process of it. Insist that anyone who wants to be a legal practitioner attend or is trained to say, is skilled as a mediator. In negotiation skills, those skills are necessary. Mandated that the institutes, the universities, all the LLB, all the law students be trained on this dispute resolution forum, and not sell the adversarial system as being the one that we see in the media and the TV shows as being the best, as this is what makes me a better lawyer. It's actually putting the people first. How does it benefit the people? How does it benefit 80% of the people in my country, the one less privileged, and seeing it, advocating that this is what the process we need to use first, not mediation versus litigation. Mediation, as I said, mediation and litigation, but mediation first.
So in terms of legislation, I mean, you were saying that one, in some way, there should be some entry barrier to be a mediator. So there's an entry barrier you've created there. Who are the people who are going to in some way train and certify? There's a certain, because for me, actually where the problem lies, the vested interests waiting and already in it, trying to get in to find ways to get a hold of the pie, whatever way they can. So vested interest in relation to the training institutes, the institutions who do mediation. So there are legislations in some countries where they've said that before you come to court, before this matter goes into court, you have to go to a certain institution. Those got created. So mushrooming of all this is going to happen. The vested interests are going to take over, and whether that helps or not, we don't know. Let's see how it pans out in places. But from your side, that is something which is required. And I'm obviously on the other side. I'm saying those people exist. We have to create a legislation where there's these things don't come in the way. It's their process. They trust whom they want. Who is the colonizer to tell us whom we trust? This is where the colonization mindset in legislation comes in for me. That when you're legislating, how can we in some way tell people whom they can go to. We have to. Who are you to tell them? It's their process, it's their mediator. They can make anyone a mediator. That's what I keep saying. So for me, I'm on the other side, that it has to be a process. But what we need to legislate is what I put out, because we won't have time right now. So I put it on in my post: confidentiality, without prejudice, mediator not being brought in as a witness, and the settlement agreement as good as a court decree. Those should be as basic as we can, and mediator and everything is up to them. But we won't have time to get into that. Veerash, thank you. Thanks a lot. It's a pleasure speaking to you, and hopefully we'll be having more such interactions. World Mediation Circle, something will happen there. So any last minute kind of things? Not last minute, I'll have to be concluding, but Alex's time is up. Yeah, please.
Thank you very much for this invitation. Thank you very much for this opportunity to just speak, and also thank you very much for how candid you are, how open you are, and you create this brilliant environment for all of us to speak. So thank you, Vikram.